A beneficiary designation is the description of a person or persons you want to receive a particular asset upon your death. It establishes how to distribute the asset, and it allows it to avoid potential probate costs under a will. In this video, we will cover the types of beneficiary designations, who can be named as a beneficiary, what assets are payable or transferable upon death, 3 mistakes to avoid, and other ways to transfer assets. First, let's review the types of beneficiary designations. There are 2 types of beneficiary designations: pay on death and transfer on death. A pay on death designation authorizes an institution to pay out a financial assets balance to the designated beneficiary. In contrast, a transfer on death designation transfers the ownership of an asset to the designated beneficiary. Next, let's cover who can be named as a beneficiary. Beneficiaries can be charities, children, family members, friends, or spouses. Minors can be named beneficiaries but will need a guardian to manage the asset. In some cases, you can designate a secondary and tertiary beneficiary. If you prefer to designate your estate as a beneficiary, the asset will be distributed according to the instructions laid out in your will. Additionally, it's important to know what assets are payable or transferable upon death. Payable and transferable on-death designations apply to many assets, including bank accounts, life insurance policies, motor vehicles, real estate, retirement accounts, savings bonds, and security accounts. Now, let's go over 3 mistakes to avoid. Know that beneficiary designations do not protect the assets in the instance of incapacity, so your beneficiary will not gain access to the asset until your actual death. Beneficiary designations are not standalone estate plans. They function as small factors of a larger plan that might also include powers of attorney, a revocable living trust, or a will. Reviewing designations regularly is crucial, particularly after notable life events such as the birth of a child, death of a beneficiary, divorce, establishment of a business, or marriage. Without this oversight, you risk leaving assets to an unwanted or ineligible beneficiary, such as a former spouse or deceased relative. But what about other ways to transfer assets? Assets owned jointly automatically pass on to the surviving owner. A trust identifies a trustee to manage assets on behalf of a beneficiary and establishes terms and conditions for transferring the assets. Any assets that are not transferred by ownership, beneficiary designations, or a trust will be transferred according to instructions in the deceased's will. If the deceased does not have a legal will, the remaining assets will be dispersed according to the state's laws in which the deceased resided. So, you want to know where to find legal documents online. If you need a last will and testament, living trust, living will, power of attorney, or any other form, we have thousands of state-specific, ready-to-go templates available for you to download, all for free. Go to eForms.com to get your forms instantly.